I'm Waqar Rizvi, and this is Scope. In today's first segment, we're going to discuss Donald Trump's impeachment trial. He has been fully acquitted at this time, even though Mitt Romney did side with the Democrats. He's, of course, a Republican senator as well. He did side with the Democrats specifically on the obstruction of Congress form of those impeachment articles that had been brought forth to the Senate from the House of Representatives. What does this mean, though? Where did the Democrats go wrong? How was Trump able to win this trial at this time? How is it that Republicans didn't call a single witness either, be it Bolton or otherwise? Let's discuss all of that a bit further. We're now joined by Allan Dodds-Frank, who is an investigative correspondent based in New York. He's first investigated Trump in the 80s. He's formerly been on ABC, CNN, and Bloomberg. He's also former senior editor at Forbes and former president of Overseas Press Club of America. He's joining us now from New York. Also joining us from New York is Nicholas Mucerino, who is an independent analyst of international affairs with a focus on the former Soviet Union and the Middle East as well. Nicholas and Allan, good morning to you both. Allan, let me start with you. What do you make of the acquittal? Obviously, no surprise there. We knew this was going to occur because of the way the numbers work out in the Senate. But nevertheless, it's important, isn't it, that Donald Trump has come out, in his view, victorious. Is he victorious?
He is not victorious, and the question you should be asking is, where did the Republicans go wrong, not where did the Democrats go wrong? The question is, what happened to the rule of law, which the Republican Party once believed in? To have a trial with no witnesses, no documents, and to allow the Trump administration to pull off a complete cover-up by refusing to allow witnesses or release any documents to the other branch of government, the Congress, is reprehensible. So Trump is not impeached. I mean, Trump remains impeached, as Nancy Pelosi said, and he is not innocent. He is acquitted by the Senate, but he remains charged. And it's hard for me to imagine that people, even in middle America, think this was a fair trial in any sense of the word. They've seen too many crime shows on television to think this is real. And the problem is that Trump, if you look at his behavior when he had a press conference yesterday to proclaim his innocence, thinks he was elected dictator. It's just terrible.
Nicholas, I wonder what your thoughts are on this, because as Allan there pointed out, Trump essentially celebrated yesterday, didn't he? And he ripped into his opponents, calling them liars and a whole bunch of other words, which we probably shouldn't be saying on TV. But I wonder, where do you think his opponents did go wrong? Do you think that this was just badly played on the part of Democrats? Or is it, as Allan said, this reflects badly on Republicans themselves?
Well, I definitely think that Allan raises a very good point where a lot of the onus should be placed upon the Republican Party under Mitch McConnell. He and many other GOP senators made it clear from the beginning that, unlike in a traditional trial where you would seek to have impartial jurors, you had Mitch come out and say very early that he was coordinating their impeachment defense strategy directly with the White House, the prime defendant in this case. And then you had other significant Republicans, including, of course, South Carolina's Lindsey Graham, openly state that he is not going to be an impartial juror. Other senators carried on in that line of argument. The one mistake that I would say that Democrats definitely made was the fact that they did not choose to drag this proceeding out probably a bit more than they could have, whether it was through a court fight that would have brought out documents along the way that would have supported their case, and then that would have been politically very explosive material, probably along the lines of an election year. You even saw at the last minute the pitch by one of Rudy Giuliani's indicted associates, Lev Parnas, to have material that was lifted from his case over here in Manhattan being included as part of the impeachment package. But Democrats did not wait for that opportunity to start cooperating more extensively with Mr. Parnas, and then Republicans just seized upon it as a way of just attacking the process itself. You heard that throughout the trial, where Trump's defense team openly said this is not the duty of the Senate to make up for the shortcomings of the House. And even if there's probably still enough evidence to say that President Trump should have been found guilty, they use it as these small shortcomings the Republicans used as cover to cast their votes in favor of impeachment.
Okay, so then, Allan, the question comes to mind then is, sure, we can talk about the fact that Republicans were not impartial in this process, but that same argument can be made for Democrats, right? They weren't impartial either, were they?
You're not supposed to be impartial. The question is whether you prejudge the results before you have any evidence or any witnesses. It was comic the way this was conducted. It in no way bore any resemblance to an actual judicial proceeding or examination of the facts. I guess that's the point. The facts were examined without any witnesses, without any new documents, and with everyone who had firsthand knowledge being blocked by Trump. And Trump's behavior yesterday is what I'm talking about. His administration did two things. There's a thing called global entry, which you pay $100 for, and then you are able to go through the customs lines at the airports, et cetera, when you leave the country. And he has now decided that the states, such as New York, that allow immigrants sanctuary will be punished by their residents being selected out and not being allowed to apply for global entry passes. His administration's also now considering dictating the architecture for new government buildings, saying they can only be old classical style architecture. This is the behavior of a dictator, or at least a dictator in a way, yearning to be a dictator, not of a democratic, with a small d, country. And it's unfathomable what the guy is doing and how the Republicans have accepted what's going on. And I think one of the main reasons they did is that his behavior has, in fact, in my view, destroyed Joe Biden as a viable candidate, because it is hard to answer the questions about what Biden's son was doing, getting a lot of money from a company from abroad. And I think the Democrats with the Iowa results are in such disarray that you're looking at one of my former employers, Michael Bloomberg, is perhaps ending up as the only viable Democratic candidate because he's the only guy who's organized enough and has enough money to fight the repetition of lies by Trump.
Nicholas, one of the things that comes into, as Allan there brought up as well, is that, sure, if we run with the argument that Donald Trump has acted like a dictator, he's nevertheless done it by playing the system against itself in some way, hasn't he? So then this also then brings up questions about the way the system is designed. There are some major flaws within the system, the fact that Donald Trump has come out of this unscathed.
Well, that's an absolutely good question to ask in this case, because it's been frequently said since the beginning of the Trump administration that the presidency was more restrained by a matter of norms and precedents than it was by a matter of like legal leeway. Many of the things that Trump did, for instance, he got off on the charge of obstructing Congress. Not even Mitt Romney voted for that one, despite supporting the abuse of power charge. He was able to just mask in arguments such as, well, I am the president. I have this prerogative to be able to dictate foreign policy, and we engage in quid pro quos in foreign policy regularly. And then, of course, you heard one of his lawyers, one Allan Dershowitz, come out and even make the argument that, well, for the president, if he deems the national interest to be his reelection, then it's a legitimate foreign policy quid pro quo to be made. That, under any other previous president, Democrat or Republican, is unthinkable to really imagine hearing. If had it been President Obama, President George Bush, the outcry would have been massive, and then you probably would have seen a much more fair trial come along with it. But understand something too, for the Republican Party, Donald, what they, many of them, when they had their statement regarding why they voted to acquit the president, openly admitted that yes, he committed a wrongdoing, and yes, what he did was wrong. But we don't think that it is in our we don't think it is up to us to be the ones to decide his fate. It should be up to the voters in this election year. So they essentially voted him not guilty for being not guilty while still acknowledging that he's guilty. It's a strange doublespeak that they were engaging in there, which just speaks to the political calculations that was going on with many of them. And just one final point, Waqar,
Sure.
that I think is important to realize, that whether it's a Democrat or a Republican, the impeachment process itself is broken in this partisan age. It was unrealistic from the beginning that the Democrats, who have 48 seats in the United States Senate, would suddenly be able to get 67 votes to convict the president. Not that very, very few Republicans would have come around to it. Mitt Romney, as significant as he is as the Republican Party's former standard bearer in 2012, and the independence that affords him, would not have been enough to peel away very hardline senators that have tied their political future to President Trump.
Okay, so I'm just going to come in. I just want to give the final comment to you, Allan, just under a minute if you can. Do you think that this, as I put to Nicholas, does show the flaws within the American democratic system as it stands right now, and that those flaws then need to be corrected so that this doesn't happen in the future, be it a Democrat or Republican in the White House, that he or she is not able to play the system against itself and come out unscathed even after committing wrongdoings?
Waqar, I think it shows the flaws in the system in the sense that if you completely ignore and abuse the system, it won't work. I don't think the system was the problem. The problem was Donald Trump. Mitch McConnell, in his close, said that the Senate had been established by the founders, the men who wrote the Constitution, to restrain any populist fever in the lower house, the House of Representatives, which is the sole the sole part of the government that has the power to impeach. Remember, they present the facts, and then it's up to the Senate to conduct the trial. So I think it's a problem of just how the cards fell in terms of the electoral system, far less than it is a problem of the judicial system in the Congress.
Very well. We'll leave it there at that, but we thank both Allan and Nicholas for their time this morning, both of them speaking to us from New York on Trump being acquitted by the U.S. Senate at this time of those impeachment charges that were brought forth by the House of Representatives. The House, of course, dominated by Democrats, the Senate dominated by Republicans, those of Donald Trump's own party. They united behind Donald Trump to ensure he would not be impeached. Only the sole vote by the Republican Senator Mitt Romney was the one that stood out, and he's, of course, gotten a lot of heat for it, even from Donald Trump as well as others within the Republican Party. But what does this really mean? To me, myself, it seems like Donald Trump has played the system against itself in some ways, that there must be flaws within the system, or else if he really has committed wrongdoing, why hasn't he been held to account? Is it the judicial system that's wrong? Is it the way this entire impeachment process is designed that is wrong? Something needs revision of some sort, because credit to Donald Trump that he's been able to play the system. I mean, sure, we can be angry by the fact that even Republicans have admitted that he did commit some sort of wrongdoing. The argument is whether or not that hits the threshold of a criminal act or not. That's something that Dershowitz and others have spoken about also. But Donald Trump's come out on top, and credit to him for that. We'll be back with our next segment after this break. Welcome back, viewers. You're still here in Scope with me, Waqar Rizvi. In this segment of today's show, we're going to discuss Salvadoran migrants who have tried to stay within the United States. They've been brought in illegally, escaping persecution and other such issues within El Salvador itself. Now, Human Rights Watch has just recently released a report about how 138 Salvadorans, at the very least, since 2013 have been killed after they were deported back to their country from the United States. And more than 70 others have been, have been abused in some fashion, be they beaten, sexually assaulted, extorted, or tortured. Now, according to international law, the United States or any other country really around the world is prohibited to return anyone to a country where they will face serious risks to their life and safety. Nevertheless, the U.S. is doing so, especially under a president like Donald Trump, who is very, very tough and strict when it comes to migrants, especially those who are illegal, be they escaping persecution, human rights issues, or otherwise. As we know, Donald Trump has built that wall and has asked Mexico then to take in a lot of these illegal migrants, and otherwise there are a lot of human rights issues, of course, that come up with all of this. Let's discuss this a bit further. We're now joined by Elizabeth G. Kennedy, who is a researcher and co-author of the Human Rights Watch report entitled Deported to Danger. She's joining us now from Tegucigalpa, the Honduran capital. Joining us from Washington, D.C. is Frelick, who is the Refugee Rights Program Director at Human Rights Watch. And joining us from Rome is Lyal Sunga, who is a visiting professor at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law. Lyal, Bill, and Elizabeth, thank you to all three of you for joining us today. Elizabeth, let me start with you. Logically, as I said in my introduction, international law would bar any country to send even an illegal migrant back to a place where they know they face serious risks to their life and safety. But nevertheless, the U.S. is doing so at this point in time. What were you able to find about exactly what this process has been like at this time?
Yes. So as you mentioned in your summary of the report, we found at least 138 persons who had been murdered after their deportation between 2013 and 2019. We know that the number is actually much higher. The reason we can know that with certainty is, first of all, we had more cases than we included in the report in order to be conservative. Second of all, it is not required of migration, or it's not required of government officials to collect migration status. So this is something that goes virtually unreported. Third, where a lot of the persons who are deported live, the press often cannot enter. So as much as half of crime that goes on there is not being reported. Then we also know that certain groups like women and children do not get this detail reported. And another component of the types of neighborhoods that we call particularly or chronically violent is it's not just gangs that are committing crime, it's also state actors, death squads, and private actors. And when the state is involved, they often will hide or cover up their crimes. Yeah. In addition to homicides, we also found other types of abuses like rape, assault, extortion, torture, forced displacement. And we can also be certain that this is an undercount because those crimes go virtually unreported in El Salvador, even more than homicide. But beyond this,
If I may just come in, I just wanted to bring in Bill into the conversation. Bill, you're in D.C., so I wonder what's been the reaction where you are to the HRW report at this time. Do you think that this is not just an issue of international law, but even U.S. law, right? Because the U.S. has always said that it's, it is willing to take in persecuted peoples around the world, but now under this president, it's doing the very opposite.
Yes, I mean, as you said, the U.S. has very clear obligations, as any country does. It's called the principle of non-refoulement, the idea that a refugee, and I would call these refugees, these are people who are fleeing persecution, they're fleeing serious threats to their lives, and the asylum system ought to be protecting them. The U.S., under the Trump administration, has directed immigration judges here who are part of the Justice Department, so they're administrative judges, and essentially their boss, the Attorney General, who is a political appointee by the Trump administration, has said that generally people fleeing gang violence, people fleeing domestic violence, people fleeing because of their family associations should not be granted asylum. Well, that excludes from the get-go many of the people that feature in our report. They're fleeing gang violence, fleeing domestic violence. In addition to that, the United States has set up barrier after barrier after barrier, basically saying that people are ineligible to seek asylum here if they don't enter a port of entry, and then set up bottlenecks at those ports of entries to prevent people from being able to actually lodge their asylum claims. And as you mentioned, we now have a return to Mexico system, and I hate to even use the word system to dignify it, because it's essentially dumping people into northern Mexico without Mexico's real cooperation. There's no formal agreement here, but basically making them wait in northern Mexico while their cases go through the backlog of asylum cases here in the United States. And what the United States has also done recently is conclude what is called asylum protection agreements with the countries of Guatemala, Honduras, and El Salvador to basically say that people who transit through those countries, Salvadorans transiting through Guatemala, would be returned not just to Mexico, but to Guatemala with the idea that Guatemala then would be responsible for examining their asylum claims. It doesn't remotely have the capacity to do that. So what we're seeing is in terms of the refugee definition itself, narrowing the interpretation of that in ways that actually distort the reality so that people that are being returned to face death and severe abuse are not being protected from the definition of a refugee itself. But in addition to that, blocking access to even be able to apply for asylum.
Now, let me go to you, Elizabeth, and with a similar question when it comes to this issue of how law is enforced, really. What are your thoughts on why it is not being enforced at this point in time? Is it just simply the factor that the U.S. is such a superpower that it just gets to almost do as it pleases?
Well, certainly in El Salvador, Guatemala, Honduras, and Mexico, the United States has a huge footprint and has, for a number of decades, been able to dictate what other countries do in the region. And indeed, it commits many abuses and is now paying for the neighboring countries to commit abuses as well. We did, however, find that over 20 countries are deporting Salvadorans. Obviously, the United States is the primary offender. But many European countries, Latin American nations, and I think even one or two on the African continent have also participated. So, the Trump administration is unlikely to heed this report, but other countries can heed the information that's been documented and create a different policy in which they're not returning people to harm, to death, to torture, to rape.
Bill, you know the argument from the Trump administration side and those who would support harsher policies when it comes to immigration and even refugees entering the United States. They say that, listen, you can't just have an open border. It's an issue of national security as well. Donald Trump has, of course, as we know, in the past used some very, divisive and derogatory language even towards many of these sorts of people who do come into the U.S. What are your thoughts on that? I mean, in the sense of just balancing a sound, logical refugee policy with national security concerns, which are very legitimate.
In no way are we suggesting open borders. I mean, this is, we're really talking about human rights protections here. We're talking about fundamental rights for people whose lives are being threatened. And so there is a general rule in immigration law. There's a deference of sovereignty to states to determine who is allowed to immigrate into their country. It's not a human right to immigrate, and we don't oppose deportations per se. I mean, that's certainly well within the scope of international law and well within the rights of governments to deport people. But governments are not allowed to deport people to places where their lives or freedom would be threatened. That's customary international law, and it's also a treaty obligation. The United States has signed and ratified the Refugee Protocol, which implements the Refugee Convention, and have incorporated that into U.S. law. Now, the question then becomes, how do you interpret that law? How narrowly do you interpret it? And do you provide access to people to the system where you can have your claims examined in a free and fair way? And the United States has blocked access and has interpreted the law as narrowly as it possibly can, to the point where it's not protecting people that need to be protected at all. So, the basic point here is that to be a refugee is, in a sense, we've established it's an existential reality. I mean, these people being killed, we've documented people being killed who shouldn't have been sent back to their deaths. The matter of who gets official refugee status is a question of discovery. Do you examine the claims, and do you find people who really need to be protected? The U.S. has failed to do that, and that's the point of this report.
Okay, so the U.S. has failed to do it. If you can hear me clearly, I wanted to also ask about the European side of all this, because it seems the Europeans are taking lessons almost from what the U.S. is doing, right? I mean, certainly the issues are not exactly the same, but they're quite similar in the fact that they're harsher now immigration policies in many places across Europe. What are your thoughts, Lyal, on that, and how this affects, of course, international law, and why that isn't being actually applied?
Well, it's a very good question. The European approach has been equally restrictive, to the one taken in North America. Except there's a big difference between, let's say, Canada, which has been quite flexible and I would say quite humanitarian, and actually overtook the United States in terms of refugee resettlement, which is a slightly different issue, but it's also part of the refugee process. And the Europeans in general, I mean, the walls have come up, and there's been a lot of public opinion that's been, kind of going up, pushing those walls up because of the alarmist rhetoric and some right-wing tendencies in some of the jurisdictions here. But I don't think anybody comes close to what the Trump administration is doing, because it's one thing to try to manage very heavy refugee outflows, which did occur from Syria and Iraq and Libya. Those are real problems. And on the other hand, doing the kinds of things that has been inspired by Trump's political advisor, Stephen Miller, who's, the far-right nationalist who's been found in November 2019 to be promoting white nationalist publications, conspiracy theories. And these measures are what really has gone beyond anything that other countries have done. I mean, all countries have been a little bit more restrictive. Let's just remind ourselves, separating children from their parents. This is Kirstjen Nielsen's mandate for a while, until she got fired because she wasn't extreme enough to deter refugee, claims, slowing official border processing, prolonging administrative detention, imposing fees on the right to seek asylum, also putting restrictions on the right to work instead of within 6 months after filing a claim to a year, barring asylum from those transiting another country. I think this was mentioned earlier. All these things seem to be very well calculated with an inhumanitarian motive, and that's, I think.
Lyal, just because we're running out of time, I do apologize for coming in, but I just want to do the final word, in fact, and I wanted to ask you, why do you think it is that all the bodies around the world who are responsible for ensuring that international law is applied, be it the UN or otherwise, why don't they have enough teeth or weapons in their arsenal, for lack of better words, to be able to then hold all of the above countries, be it the US or others, accountable?
Well, notwithstanding the fact that, and I think this has been mentioned very well, that the principle of non-refoulement, that you can return anyone to a place where they would face danger to life or limb or liberty, notwithstanding that principle, there is room within the sovereign jurisdiction of states with regard to how exactly they implement, refugee law. A certain amount of room. It's not endlessly elastic, but states use the maximum flexibility that they can, and simply because states themselves never surrendered wholly, immigration law and refugee determination process entirely to UNHCR or to the United Nations or to other international bodies. So it's a pull and push of political negotiation and multilateral cooperation, and ultimately political will. So maybe we just round that up in a general sense.
Wonderful. We'll leave it there at that as our final thought, but we appreciate all three of you for your time. That was Lyal speaking to us from Rome, Bill speaking to us from Washington, and Elizabeth, who is speaking to us from Tegucigalpa. We appreciate, of course, the insight and context you've all brought to this conversation. It's an important conversation, isn't it? Because in this case, of course, Human Rights Watch has spoken about in this report that we've been talking in this show has been just about Salvadorans. However, this does not only, of course, affect Salvadorans. It's affected a lot of different nationalities across Latin America, those who are fleeing persecution. Many people would even argue that a lot of that persecution may very well be something that the U.S. has a hand in as well in some fashion. That, of course, is up for debate and argument. Nevertheless, the U.S., as any responsible country around the world, has an obligation to not send people back knowing full well that they will be at risk, that their lives will be at risk, be they just for death or torture or otherwise. Countries around the world sign on to international law for that reason, so that there are checks and balances and that everyone is following the law to the best of their abilities. Is the U.S. doing so? What kind of an example is it setting? What are the European countries, as I had mentioned to Lyal as well? Are they setting a good example for the rest of the world follow? After all of the above countries claim that they have moral authority over the rest of us around the world as well. I'll be back with my final segment after this break. Welcome back, viewers. You're still here on Scope with me, Waqar Rizvi. In this final segment of today's show, we're going to discuss the United Kingdom, which has promised now to amend early prison releases, specifically when it comes to terror offenders. We know that recently there was a terrorist incident there in the United Kingdom, in London, where a gentleman by the name of Aman, I believe, Sundesh Aman, I believe, was released from prison early, a year or so into his jail time, and there is now talk on the part of Boris Johnson to now change those rules. But this is specifically for a very one-sided type of terrorism, isn't it? And we call that Islamist terrorism, jihadist, whatever the term is. But this does not cover all forms of extremism or terrorism, seemingly at least. And I'll put that to my guests in just a moment also. There's a lot of talk about whether or not this is the best policy to be following at this point in time, because there's also a concern of de-radicalization, isn't there, where people who go into the prison system in this fashion, are there really systems in place to de-radicalize these people, or do they in fact come out even more radical because they're surrounded possibly with people of their own sorts of thought patterns or otherwise? And then why, if, for example, a terrorist offender goes into jail and is possibly going to recommit such violence, why isn't that applied across the board to somebody who is, for example, a far-right extremist also? Let me put that to our guests. Our guests joining us now are Imran Shah, who is with the Muslim Public Affairs Committee in the UK. He's joining us now from London. Also joining us from London is Francis Hoar, who is a barrister who specializes in public and human rights law. He's practiced criminal law for 10 years. Francis and Imran, thank you both for your time today. Francis, let me start with you. Do you think that the Johnson government does need to revisit these early release rules for terror offenders?
Well, first of all, the difficulty here is that we don't seem to know exactly what the policy is going to be and the draft legislation is going to be. I haven't read any draft legislation yet. Yeah. You're absolutely right to highlight the difficulty of identifying what is a terrorist offence. Now, there are a number of offences that have the word terrorism in them, but terrorists could be convicted of offences that could apply to anyone. So identifying what the offences are is very important for a number of reasons. You also are right to identify that this is a measure that may or may not apply to particular terrorist organisations or individuals. My understanding is, my strong belief would be that it would apply to all terrorist offences, regardless of their motivation. It would be extremely difficult for the government and for the United Kingdom and the European Court of Human Rights, if it got to that stage, to defend it if that was not clear issues of discrimination, religious discrimination and other issues. It would have to apply to terrorism across the board. The other issue is, would it apply to particular offences, or would it apply to some form of designation which was by the government? The first would be considerably easier to defend in the Strasbourg Court and the European Court of Human Rights if it came to be challenged, and in the United Kingdom courts, because of course the Human Rights Act transposes the Convention and ensures that Acts of Parliament must be compatible insofar as it is possible to interpret them. So those are a number of different issues. Which will the courts and the government will need to, the government in the first instance and Parliament will have to grapple with. Yeah.
All right. So Imran, I wanted to get your thoughts because, since this incident with Sundesh Aman occurred there in the UK, there has been concern, right, about this. And some of it does seem very legitimate, doesn't it? That you don't want to just release people without knowing if they've been de-radicalized in some fashion or other. I mean, if this person is prone to violence again, why even release them early?
Certainly, and that's a genuine concern. It's not something to be sniffed at. But again, when it comes to legislation, the devil is in the detail. So they talk about trying to stop automatic release. Judges already have that power when it comes to these crimes. And really, there isn't that much detail on what they're proposing. So at the moment, what we do know is that they're trying to push the minimum required of a sentence to 2/3 as opposed to a half. That's not going to deal with the actual problems of when they are released to society. There has been certain statements of trying to use lie detectors and other sort of novel ways that are really not accurate in trying to determine someone's behavior or intention. So really the government has been accused by large sections of the media, including organizations like ourselves, of using this as a PR stunt as opposed to seriously dealing with this issue. And this is in a background where there has been, way before the last general election, it's been reported massive cuts in our prisons in terms of funding, in terms of staff, massive cuts in terms of policing. And there has been many, many cases where these individuals, they have been released, and it's been found out that actually the security services knew about them. In some of those cases, their own family members have reported them to those authorities, and nothing was happened. So in that situation, you only really have two scenarios: either these people are left to their own devices deliberately, or there's a massive problem, a significant problem of underfunding, and these measures don't solve that at all.
All right. So then, Francis, I wonder, as I'd mentioned in my introduction as well, there is that issue of de-radicalization as well, right? And even Boris Johnson has mentioned that this is a challenge at this point in time. How do you think, or what do you think, sensible legislation in that regard should look like?
Well, the difficulty the government perceives in this is that for most offences that were sentenced before this year, because I believe the government is introducing legislation to change certain offences so that release is automatic only after 2/3 of the sentence. Currently, for most offences, release date is automatic at half the sentence, and that's read out by the judge in court and is known to the prisoner, which is one of the objections to this. It's not actually right that, as was suggested just now, that the judges have any power to change that. They don't, nor does the parole board. So I suppose the government's take on this will be that the parole board has no intervention and has no ability to say that a person who is imprisoned for a standard offence, and standard could be very serious, it could be anything up to any sentence that is short of life imprisonment that has a standard prison term, will have an automatic release date, whereas those prisoners who are sentenced to life imprisonment will have a tariff, and that's their minimum sentence. And then after that tariff is reached, which might be, say, 10 or 15 years for murder, it's typically 15 years upwards, then the parole board will have to assess whether they are safe to be released, and it will have all sorts of measures to determine that. They're not obviously infallible, and sometimes prisoners offend again, and there's no way of preventing that. But the government would say that in certain cases, wider than simply where people are in prison for life imprisonment, the parole board needs to have some form of means of preventing release. Now, that would only under the legislation.
Francis, if I may come in for a moment, and I wanted to ask you a very direct question. I want to put you on the spot, but I will ask you this nevertheless. Do you think that there is, in some ways, especially after this latest terror incident there in the UK, that there is almost this biased approach to, as I said, Islamist, jihadist, whatever you want to term that form of terrorism? Do you think that there's almost this bias that is the only form at this point in time of terrorism which needs to be tackled in this specific fashion, where you just, you cancel out early release altogether? Or do you think that that parole board judges or whoever is sitting on those parole boards, that they are going to be really doing this in a fair fashion? Because again, as you mentioned, they're not infallible in any way, either way, really. But do you think that in some ways that this will bring in a double-tiered approach, which many are saying is a concern now?
Well, there's two possible meanings of bias here. Firstly is whether or not the government and parliament and perhaps the media and the wider population are biased against particular types of offenders, and perhaps whether there's some form of Islamophobia there. That may or may not be. It's probably right to say that the terrorist incidents now are disproportionately Islamist terrorist offences. The statistics would tend to support that. In 20 or 30 years ago, terrorism from Northern Ireland, both loyalist and Republican, was prevalent. These things go in waves, and that is how it is. The second question, and so that's an open question. The second question, though, is whether or not judges and parole boards are biased. A more important question, because of course they determine the individual parameters, the sentences, and whether or not people are released. There's no evidence to suggest that there is sustained bias there, and strong evidence to suggest that offenders are sentenced in an impartial fashion. Those sentences are subject to appeal. If there's any incidence of bias, you would hope that would be corrected by the Court of Appeal, or in very rare instances.
I'm going to cut you off, Francis, just because we're running out of time. I do apologize. I just want Imran the final word. Imran, tell us about the concerns on the part of the Muslim community in the UK when it comes to, I know you've already laid out a bit of that for us, but will this bring in a double-tiered approach, as many are saying is the main concern right now?
I mean, there is a lot of fear and concern in regards to this. Already last month, The Guardian reported that Muslims convicted of even small crimes of extremism, like online offences, are given sentences 3 times longer than their white equivalent. So there's already bias. As of 2 years ago, the UK terror chief has said that the biggest threat is not Islamic extremism, is actually far-right extremism, and that is across society. And again, that reflects in terms of the political precedents. You have a number of Muslim groups that are extreme, have been subscribed, but when you look at Britain First, EDL, and others, these are heavily extremist, heavily sort of Islamophobic, and they are promoting violence. And so you have those ideas essentially allowed to ferment in society. The government's not shutting them down, and some would argue actually their ideas are prevailing in the press and even in the highest levels of government. So there is a massive fear in regards to a two-tier system, and there's already evidence for that inside the justice system and outside of it.
Very well. We'll leave there as a final word. I know we just scratched the surface of this issue, but we'll try to have you both back on to continue this discussion at a later time. We appreciate both Imran and Francis speaking to us there from London and for giving their points of view on this issue. It's complex in the sense that terror offenders who are known or prone, I should say, to violence, to recommit violence, or to commit violence at all, if it's somebody who hasn't even committed violence in any physical or other fashion, why would they be released early? Why would they be given any such credit at all? And this should be across the board, shouldn't it? It should be for far-right extremists as well as those who would be termed Islamist, jihadist, or whatever the term is that the UK government would use for them. Will this bring in, as Imran there said, a two-tiered system where it's unfair, where it's just the Muslims who will be targeted, who have committed any sort of even minor terror offense within UK law? Why not target far-right or right-wing extremists in the same exact fashion? They are also a huge threat to safety and security, but on the other side, of course, to the Muslims within the UK or other minorities as well, especially at a time of Brexit where, we know that the sort of rhetoric that has come out has been ever and ever more extreme in some regards. So how exactly and what exactly would sensible legislation look like at this point in time? I imagine that is the challenge that the UK government of Boris Johnson is currently grappling with, as Francis there had correctly mentioned as well. We'll leave it there for that. I've been Waqar Rizvi. Thanks very much for watching.